2, 1.
This honorable court is now in session.
Good afternoon. On behalf of Judges Frierson and McBrayer, I'd like to welcome you, virtually anyway. And if there's no announcements or anything, we will get started. Ms. Dempsey, would you please call the case?
Natasha Victoria Shoulders et al. Versus Madison Lisa Martin.
Good afternoon, Your Honors. Thank you for giving me the opportunity to represent grandmother and present her case. It is my hope that during this oral argument, I will be able to do three things. First, I would like to address the hoped for outcome of the case as advocated by the grandmother appellant. Second, I would like to provide an overview of the case. And third, I would suggest that I would be happy to answer any questions I may answer. By way of overview, the grandmother's hoped for outcome of this appeal is that this court will reverse the trial court, dismiss the case, and reinstate her original grandparent visitation order. There are at least two possible vehicles by which this court could come to that result, and I will address them after providing a brief overview of the case. By way of overview, this case involves the termination of a grandparent visitation order that had been in place for about 5 years, and there is no dispute in the record that for that 5-year period, visitation was regularly and sustained and consistently exercised. As part of the agreed visitation order, there was language in the agreed order that was approved by the court in the adoption case that any action by the grandmother that the terminated biological father, who is a statutory rapist and on the sex offender list, that the grandmother cannot take any action to arrange, facilitate, or act as a conduit for any contact between the grandchild and her terminated biological father. We would submit, Your Honors, that that is not a typical no contact order as in an order of protection case, but that the scope of that order would require affirmative action on the part of the grandmother for there to be a legitimate finding that she violated the order. We would submit she did not violate the order, and that even if she did, the standard of modifying a grandparent visitation order, which was set forth in Lovelace versus Copley, was not met. Under the Lovelace versus Copley standard, the burden of proof is on the party seeking to change grandparent visitation to demonstrate both a material change in circumstances and also that as a result of that material change in circumstances, it serves the child's best interest to modify or terminate the grandparent visitation. In this case, we would submit that the trial court did not apply that analysis. Rather, contrary to the Lovelace case, the trial court looked at the preferential role that parents are given as having a constitutional right to raise their children. And under the Lovelace versus Copley case, it is very clear, according to our state Supreme Court, that the initial grandparent visitation determination requires a finding of substantial harm to the child if the relationship between the child and the grandparent would not continue. Once that initial determination is made, which would have been part of the agreed visitation order for the grandmother, that standard does not have to be met a second time. It follows the case and the normal modification of visitation standards apply. In the trial court opinion, the trial court specifically said the trial court does not find there is sufficient evidence to establish either substantial harm or severe emotional harm would likely occur as a result of ending the visitation with the grandmother. We would submit that as the wrong standard. And when a court applies the wrong legal standard, by definition, it abuses its discretion. So we would submit that since the wrong legal standard was used, the trial court abused its discretion and should be reversed. The appellees argue that remand would be a more appropriate remedy if there are insufficient findings of fact or if the court is not sufficiently clear as to how it's reached its legal conclusions. We would submit, as outlined in our brief, that there is a line of cases that allows an appellate court, if faced with a sufficiently developed record, to quote unquote soldier on, so to speak. And we would submit that this record is well developed and extensive, and that in this case, we are asking the court to soldier on, apply the correct legal standard of Lovelace versus Copley, which is set forth in great detail in the brief, listing all the factors set forth in the grandparent visitation statute. And we would submit that as a result of applying the correct legal standard, this case should be reversed. So that we would suggest is the first path by which the court can come to our hoped for resolution of reversal and reinstatement of the grandparent visitation, because as outlined in great detail in the brief, we submit neither has there been a material change in circumstances, because any of exposure of the child to the terminated biological father did not harm the child, nor has there been a best interest analysis on the basis of which terminating, suspending, or reducing grandmother's parenting time would be in the child's best interest. There is another interesting issue in this case, in that in 2019, there were changes made to the adoption law of the state, which changes permit so-called post-adoption contact agreements under certain circumstances. In 2019, this petition was filed to change the agreed grandparent visitation order, and it was filed after the adoption of the post-adoption contact agreement law. So we would submit that because the petition was filed and the case was heard after that law became effective, that as a result, it should be applied to this case. The appellant and the appellees differ on that issue. And one determination the court may want to have to consider making is, what does it mean to apply that statute retroactively? As I read the appellee's brief, retroactive application appears to mean applying it to an order that was not crafted under that law. From our perspective, retroactive application means applying a remedial law to an agreed grandparent visitation order that predates the law under circumstances where the modification of the agreement is filed after the law kicked in and the trial is held after the law is kicked in. If we review the post-adoption contact agreement law, we will find that it has a large number of pre-litigation requirements. These include involvement of an expert, counseling, and/or mediation. The record would appear undisputed that none of these requirements were met in this case. And that is our second suggested potential vehicle to getting to the appellant's desired outcome. If the court were to apply the law as written prior to the filing of the petition and prior to the litigation on that petition, if it were to apply that law retroactively to the agreed grandparent visitation order that predates the law, then if the court reaches a conclusion that the pre-litigation requirements are jurisdictional, we would be once again back at appellant's desired outcome, which is dismissal of the case and reinstatement of the original grandparent visitation order. So that is the second way we could possibly get to the hoped for outcome of the appellant. If this court, in conducting its review and analysis, focuses only on one case, the case that I would suggest most strongly is Lovelace versus Copley from our state Supreme Court. That case is very, very similar to our case in that it involves an agreed order of grandparent visitation. The Lovelace court emphasizes how important agreements reached by parties, which are contractual and then become enforceable and final when signed by the court, how important these things are. The court focuses on the importance of settlement agreements in the judicial system, and in that case did not allow the parents to collaterally attack that order. In this case, our brief sets forth certain arguments as to why the appellees ought to be stopped from asserting the order is not valid. So if the court takes the same position as Lovelace versus Copley, it can then follow the analysis where there also was an issue of adoption law being general and a more recent, more specific law, in that case, a grandparenting statute being passed. So I want to thank you.
What is the effect of the grandmother on the agreed order of the grandmother violating the provision about the biological father?
We contend she did not violate that provision.
I know that, but if we should decide she did, what would be the effect on that agreed order?
It would be our submission that then it could be considered a material change in circumstances. And under the Lovelace analysis, the trial court would then have been obligated to proceed with the best interest of the child analysis, which it failed to do.
Okay. Thank you.
Thank you.
Ms. Massey.
Good afternoon, Your Honors. You know who I am. My name is Sharon Massey, and I represent the appellees, Mr. and Ms. Shoulders, on behalf of their child, also Hannah Rose. First, I want to address the. I put in my brief, and my learned adversary pointed out that I mistakenly said the year 2020 that the post-adoption contact agreement went into effect. It actually went into effect March 22nd, 2019, but there was a small amendment on March 6, 2020. And I said it was March 6, 2020. So I just wanted to correct that. It's in section 4. But I want to address that first because it seems to me to be the simpler issue. Valid post-adoption contact agreements are very specific. They are between two parties and maybe a third, but it's always between an adoptive parent or prospective adoptive parent and a biological parent. And sometimes if the child's 14 years or older, that child also becomes a party to that contract. And there are specific provisions in there. It has to be in writing, signed by all the parties, not just an agreed order. There are specific warnings that must be put in there. And in a post-adoption contact agreement, it does require mediation and some other things. However, post-adoption contact agreements are not intended to be between relatives and adoptive parents. There is absolutely no provision for any other person other than the adoptive parent and the biological parent to enter into one of these contracts. So that argument is simply misplaced. On the issue of the abuse of discretion, Lovelace does state that there needs to be a showing of material change of circumstances. However, Lovelace differs from this case in that Lovelace had in their final decree of adoption a specific statement that their grandparent visitation was not to be disturbed. In our case, that is not in the final decree of adoption. So this is simply a contract. The grandmother, it is significant that she violated the terms of this agreed order, because in the agreed order, it specified because of the biological father's terminated status and the fact that he was on the sex offender registry for the rape of the mother of this child, she was not to allow contact nor facilitate. And on page 2 of Judge Goodman, the trial court's order, he specifies what it is she was not supposed to do. And even in Lovelace, what the court found is that a violation of the terms of the orders can be a material change of circumstances. Now, Judge Goodman specified that when this child was in the care of the grandmother, she was not to do certain things. No communication or contact with Mr. Nieves or his family through, and I quote, through action by Ms. Martin, and she shall not arrange, facilitate, or act as any conduit to allow Hannah and Mr. Nieves or any of his family members to speak or visit, nor shall she encourage this child to seek him out. This grandmother proceeds to give this man a false name. She allows him to come to her home. She arranges for him to be at a dance competition where there are numerous children, and her testimony changes over time. Her argument or her excuse is, well, I was ambushed in the first hearing and I didn't know what I was saying. But the court found that her actions did do just what she agreed not to do. And not to mention exposing a child to a person who's listed as whether it's her terminated biological father or not, exposing a child to a person who is listed as a violent sex offender on the Tennessee Sex Abuse Registry is in and of itself putting that child in harm's way. The court found that she violated this agreement and therefore she caused a change of circumstances. And all of these things, it wasn't just one change in circumstance, it was her actions all along. And finally, at the final hearing, she declined to even acknowledge, even with her own experts sitting there, she declined to even acknowledge that she had done anything wrong. Even today, her argument here is she didn't do anything to violate that court's orders. The facts themselves, the facts are that she allowed him to come to her house. He came to birthday parties and a barbecue. So the facts themselves show that she did do that. Now, I understand that even the appellants ask for that this court could even, if the court believes that the trial court applied the wrong legal standard, then this court can conduct the de novo review of the record to determine where the evidence lies. The record is voluminous, and there's significant evidence in there to show what was going on. And while the trial court didn't use the words change of circumstances, substantial risk of harm and material change of circumstances have gone hand in hand in many cases. A substantial risk of harm is and can be at any time a material change of circumstances. Lovelace v. Copley also says violation of a court order is a material change of circumstances. And then after that, the court goes on to list, even though the court didn't say, okay, factor number one in 366307, the court doesn't say that. But the court goes into talking about the relationship between the child and the grandmother, how long this relationship has gone on. In the factors of 366307, the court talks about the existing emotional ties of the child to the grandparent. In fact, the court finds the child really doesn't have any significant attachment to the grandmother, but considers her two 12-year-old children to be the child considers them to be her best friends. She doesn't mention the grandmother as far as I'm very attached to her. The court talks about the length and the quality of the prior relationship between the child and the grandparent, and the preference of the child, if the child's determined to be of sufficient maturity, and the effect of the hostility between the grandparent and the parent, and the willingness of the grandparent to encourage a close relationship. The others don't really apply in this case, the rest of the factors, but those first four are very specific in the trial court's rulings. And I would submit to Your Honor that regardless of whether you think there's the court used the right language, material change, substantial risk of harm, it doesn't change the outcome here. The outcome would be the same. And it's our position that the court didn't incorrectly apply the law. The court certainly didn't incorrectly apply the law as it pertains to post-adoption contact agreements. The court found that wasn't appropriate. And to retroactively apply that to this situation, that statute, when it was created, was not intended to be retroactively applied to adoptions that have occurred for years before this. Thousands of adoptions would be overturned or trying to be modified by birth parents if that were the case. And it's our position that that was not what was intended by that. The other abuses, the other kinds of abuses of discretion in that standard say that the court's ruling caused an injustice by applying the wrong standard. The court's ruling did not cause any injustice to the grandmother. The court applied the standard, and the only injustice is that the grandmother wishes to continue to believe she hadn't done anything wrong, and for the grandmother to say, well, in the words of Dr. McMillan, no harm, no foul. So the question was posed to him while he was on the stand. If a person who is driving under the influence doesn't get pulled over or doesn't get arrested, does that mean that he didn't do anything wrong? It seems to me that the grandmother is trying to say, well, since this man didn't molest this child or do anything to physically hurt her, then there's nothing wrong with this contact continuing. Even her own, even Dr. McMillan said, there has been contact, and he said he was shocked. I don't know the exact words, but he was appalled at what the grandmother was trying to say. There are some other issues that that the grandmother brings out. For example, also, I would like to address those few because there are several. That whether the failure for the court to allow Dr. McMillan to evaluate this child was caused the trial court to have a clearly erroneous assessment of the evidence. Whether or not to allow an expert to see a child is at the discretion of the trial court. And I believe what the trial court said is it's the behavior of the grandmother that we're talking about, not the behavior of the child. And that there was no need to evaluate this child because everyone was attempting to protect her. I mean, her interests are also to be considered. She had a guardian ad litem. The guardian ad litem did not believe the child needed to be evaluated because the guardian ad litem said the child is doing well, she's well adjusted, and even after the cessation of the visitation with the grandmother, the child continued to do extremely well. The trial court did not decide the case on an erroneous assessment of the evidence. Whether we liked the words he used or didn't, the assessment of the evidence was pretty clear. And I don't know that he used the exact words, but Many times the court questioned the grandmother about her credibility and what she was doing with regard to the grandchild. Whether the grandmother also asks that the trial court be mandated to recuse themselves in the event of a remand. I would submit to Your Honor, they never ask, the grandmother never asked the court to recuse himself that I'm aware of. And the court didn't take any action outside of the hearings. And there was no basis ever listed or raised for him to be recused. So I would submit to Your Honors that based on the application of the law and the failure of them to show that there's an abuse of discretion, and the fact that the court resolved the issue on an accurate assessment of the evidence, that there has been no injustice and that the Court of Appeals ruling ought to be affirmed. I'm happy to answer any questions if you have any.
Seeing none, thank you.
Thank you, Judge Bennett.
Ms. Hope?
Thank you, Your Honor. 5 points that I would like to briefly.
Ms.
You're
Hope, back on
muted.
mute.
You're on mute.
I apologize. Technology is not my background. Sorry. Thank you
Okay.
for pointing it out. The first point is that if we look at the post-adoption contact agreement statute, which is 36-1-145, it specifies that it cannot be the basis for setting aside adoptions. And in paragraph A, it specifically refers to a child who is being adopted or who has been adopted. So I would submit that is contrary to the appellee's argument that it can't be applied retroactively because it applies to children who have been adopted. And there's not going to be chaos in the adoption world because the statute specifies that it's not a basis for setting aside adoptions. Second, there were references in appellee's argument to a voluminous record. That is absolutely correct. There is a large record. But what it boils down to is that most of the testimony that supported the judge's conclusion came from the child. The child's parents acknowledged they had no firsthand knowledge. They only knew what the child or other witnesses said. And our brief points out in great detail the inconsistencies and the changes of the child's testimony, which were not addressed by the trial court, and some of which were even acknowledged by the expert for the appellees. And she noticed that, for example, the child testified about hamburgers and hot dogs being on the menu at the cookout. Then the grandmother testified that her husband had gout, so they wouldn't cook red meat. And the next time the child testified, there were no hamburgers on the menu. And those inconsistencies are set forth in detail in the brief. The third point I would like to make is that the trial court should have applied this post-adoption contract law to the order that was pending, because the court is urged by appellant to read the parties who can be part of this post-adoption contract agreement as far more broader than the parties listed by the appellees. And on pages 11 through 13 of the reply brief, we set out a different reading, which refers to reading of the parties to the adoption versus the parties to an agreement. So we would ask the court to take a broader view. And with that, I will just say that there are evidentiary rulings set forth that could lead this court to review the record and find that the trial court's evidentiary rulings were somewhat inappropriate and personal.
Thank you. Thank you both. And Ms. Dempsey, would you adjourn court, please?
This honorable court stands adjourned.
Thank you.
Thank you.